appeals in the matter of the Commissioners for His Majesty's Navy or Customs and applicants in the Post-Prudential Application Group litigation and another.
Yes, Mr. Arnold.
I'm obliged, my lord. I appear for the appellant taxpayers. My learned friends, Mr. Hewitt, King's Counsel, Ms. Belgrano, and Ms. Ruxandu represent the revenue. The court should, I hope, have a number of bundles, both in hard copy and perhaps also electronically. There's the core bundle, there's the agreed supplementary bundle. There are also two separate supplementary bundles, small ones filed on each side. I should say a word about our one. Our proposed supplementary bundle, it contains 3 witness statements, and the short point is that the First-tier Tribunal accepted the evidence of the taxpayers' witnesses in full. That was paragraph 93 of its decision.
So we rely upon the UT's findings.
Yes, but sometimes it may be helpful actually to look at where those findings come from. That's the short point. I'm not intending to take up time in delving into the witness statements, but it may be useful to look at those. And as I understand it, on the revenue side, it's principally some computational material. And again, I think it's not being said that we're going to have to spend any time on that, but it may be that Milena Friend wants to take the court to some of that. And I don't think either of us envisage any difficulty with either of those matters. So I'll simply deal with certainly my material as I need to as I get to the substance of my submissions. On the authorities, I believe there are 6 hard copy bundles.
Yeah, I think so.
There is a transcript which will be prepared daily, and I hope it's convenient if we supply that to your lordship's clerks. Is probably the most sensible
and
thing.
we're grateful. Thank you.
And there is an agreed timetable, which I hope the court
Yes, and we're grateful for that as well.
I'm obliged. With your lordship's permission, what I propose to do is adopt what we say in the skeleton arguments and to develop my oral submissions in 3 broad stages. First of all, to set out an overview of the case on our side. Secondly, I'd like, if I may, to deal with the background in a couple of stages, to give a couple of illustrations of the claims that were made in this case, then to say something about the way in which the understanding of the nature of the breach of EU law developed in this area, and then to show the court the conforming interpretation that's been established by the UK courts in response to that breach of EU law. Thirdly, I'll deal then specifically with the grounds of appeal. As your lordship will have seen, there are 2 broad grounds, and they reflect the 2 principal issues that arise. So first of all, the validity of claims that were made before the conforming interpretation was established. And secondly, the interaction of Section 790 of the Income and Corporation Taxes Act 1988, which I'll call ICTA, that section conformingly construed with other provisions in the Double Taxation Relief Code, so Part 18 of ICTA. And I also, of course, need to address the findings and conclusions on the individual issues, and what I'll do, if I may, is do that as I go along in the light of my submissions on those 2 grounds of appeal.
Mr. Bramwell, I understand your 2 overall grounds of appeal.
Yes.
Do I also understand correctly that of the large number of issues determined by the UT, which reflected the numbering in the FTT, that, do I understand correctly that all those that you lost on in the Upper Tribunal are within your appeal?
There's one exception, which is issue 12, I think. Everything else is within the appeal. Issue 12 is a very particular point about a taxpayer who had income under Schedule D Case 1 rather than Schedule D Case 5, and whether that provided a reason for not...
My notes suggest that wasn't determined by the Upper Tribunal at all.
Oh, I see.
That's why I'm saying all the ones you lost in. You can come back and ask and respond to that later.
Yes, I'll make doubly sure of that. But 12 was decided by the Upper Tribunal. It's paragraph 284, but there's no appeal against that on that particular issue. But all the other issues that we lost on are live and are raised by the grounds. And on Milano Friend's side, again, just seeing the geography of this, his principal appeal points, I think, are issue 3 on withholding tax, and then there's an additional issue C,
Yes.
which is the section 811 and the management expenses, and they're dealt with in his appeal skeleton argument. And having discussed this with my friend, some of this will depend on the time, but what I had in mind, because all of these issues are interrelated, I was simply going to deal with everything. I may say a little bit less in opening about the points that truly are his appeal points, but I was going to at least say a word about issue 3 and about that additional issue when I get to them. So by way of overview, first of all, and this is, I suppose, trying to simplify even further what we say in paragraphs 1 to 14 of the main appeal skeleton. If we simplify this right down, the problem that gave rise to these claims lay in a design feature of the UK corporation tax system in relation to dividends. And the problem was this: the UK exempted dividends that were paid by UK resident companies from corporation tax, and I'll call those dividends domestic dividends. That exemption applied however big the shareholding was. So whether or not in the jargon of these cases it was a portfolio holding, that's a holding of less than 10%, or a controlled holding being a holding of 10% or more. And what the exemption sought to do was to avoid the economic double taxation of the distributed profits. So the profits had been taxed at the level of the company, and so it was desired not to tax those profits again in the hands of here the corporate shareholder. Different issues, of course, arise when you had an individual shareholder, but we're interested at the moment in corporate shareholders. That was the position for domestic dividends. That exemption didn't apply to dividends paid by companies which were resident overseas. And I'll call those dividends foreign dividends or overseas dividends. So those foreign dividends, they weren't exempt. They were chargeable to UK corporation tax. But what the UK did do was grant UK resident companies receiving foreign dividends a credit against the UK corporation tax liability. And the credit differed, as the court will have seen looking at section 790, according to whether the dividend was from a portfolio holding or from a controlled holding. So for a controlled holding, the UK gave credit for withholding tax and also credit for tax paid on the profits underlying the dividend. I should say right now, we're not dealing with controlled holdings in this case, but the vice and treatment of the controlled holdings, as we'll see, it shows you what was actually wrong with the UK system. So I have to look at the treatment of controlled holdings in order to make sense of the Court of Justice's recognition of the foreign nominal rate credit. What we're interested in is portfolio holdings, and there the UK gave credit for withholding tax only. So the credit for tax paid on the profits underlying the dividend, that didn't extend to dividends from portfolio holdings. So leaving EU law to one side, that credit for tax paid was expressly ruled out by the UK legislation, and the UK legislation, of course, didn't deal with credit at the foreign nominal rate. And I can perhaps just show Your Lordship where that comes from. It's in section 790 of ICTA, which is in volume 1 of the authorities at tab 7. divider starts at electronic page 32, but it's page 40 that I need for section 790. And this is the provision dealing with unilateral relief. And what we'll see is this is the provision that's ultimately been given the conforming construction. Leaving EU law to one side, 790 sub 1, what we're dealing with is relief in respect of tax payable under the law of any territory outside the United Kingdom. And that's by allowing that tax as a credit. That notion of tax payable, that's particularly relevant to my ground 2, but I'm going to come back to that. Just in terms of the credit that was actually given, so we're told that the relief is unilateral relief. That's then explained further in subsection 3. The credit for tax paid is set out in subsection 4. And it's the combination of subsection 4, sub 5, sub c little 2, and sub 6 that means that that credit introduced in subsection 4 doesn't actually apply in relation to portfolio holdings, because we're told in subsection 5 that subsection 4 has effect subject to the following modifications. And then it's little c, credit shall not be allowed, so it's a prohibition, read short, unless little Roman 1 is tax directly charged on the dividend, so that preserves the credit for withholding tax, because that is directly charged on the dividend, and it includes tax charged by deduction or tax at source. And then if you were to get the subsection 4 credit, otherwise, one of the conditions is that the dividend is paid to a company within subsection 6. And unpacking subsection 6, one of the conditions, focusing in particular on little a, is that there must be a direct or indirect control of not less than 10% of the voting power in the company paying the dividend. And that's really where that distinction of between holdings of 10% or more on the one hand and holdings of under 10% comes from. The language of controlled holdings and portfolio holdings, that's not part of the legislation, that's really just part of the jargon, I think, that's been used as these very long-running cases have developed. And just for your lordship's note, what I've just said is, well, the provision is set out and then its effect is summarised in Prudential High Court by Sir Launcelot Henderson, Mr. Justice Henderson as he was, paragraph 83, and it's electronic 747. I can just read it out. The observation there was, in the case of portfolio dividends, the credit for withholding tax, where it's not provided under double tax arrangements, is provided by section 790 sub 4 and 5c Roman 1, but a credit for underlying tax, although falling within the general wording of subsection 4, is excluded by subsections 5c Roman 2, 6 and 6a.
That's paragraph 83.
Yes, 747 in Prudential High Court. Now that system has ultimately been held to breach EU law. So it wasn't good enough in the case of portfolio holdings that credit was given for withholding tax only. And the remedy has been held to lie in a conforming interpretation. Now what I'm going to be dealing with under ground 1 is the validity of claims that were made seeking to assert EU law rights before the conforming interpretation was established. What we're dealing with here, with one exception, which is Avon. There may be one or two others, but the cases that are before this court, they're investment funds, with the exception of Avon, which is an insurance company. But in all cases, we're dealing with portfolio holdings, those holdings under 10%. And what we'll see is that these taxpayers formed the view that the UK system didn't treat the overseas dividend income and the domestic dividend income equally. And they sought, in different ways, to assert their EU law right to equal treatment. And what we'll see is that they asserted that EU law right using the statutory procedures that appeared to be available to them. And those procedures included filing returns on the basis that the income was exempt, or amending returns on an exemption basis, or making statutory claims to recover tax which they believed was excessive by reason of a mistake in the return. And those are the paragraph 51 claims, which I'll deal with when I address you on issue 2. So, pausing
So,
there.
can I just ask one question? And it's really a question that I don't require an answer to now, but when you come on to your grounds of appeal. But I'm a little puzzled by the way you articulate this as a breach of EU law, which is remedied by a conforming interpretation.
Yep.
Because the whole point about a conforming interpretation is that it means there is no breach.
Well, that's one of the substantive submissions I need to deal with, and I will deal with it when I get there, because my submission.
Conforming interpretation is an interpretation which is compliant with EU law.
Well, that's right.
And we apply the declaratory theory of law unless there's a relevant exception, which currently I'm not aware of in this case. And so the conforming interpretation was always the correct interpretation of the legislation.
Well, there are 2 points, at least, which I'll develop when I get to the meat of the submissions. The first, and we'll see this particularly when we look at Lord Sumption's speech in FI Supreme Court 1 in 2012, the existence of the conforming interpretation doesn't mean that there is no unlawful requirement to pay the tax, thing one. And I say that the fact that the legislation is being subjected to a conforming interpretation doesn't make the prima facie breach go away. The ultimate effect is that the breach is remedied. The conforming interpretation is a response to action that the individual takes in order to effect to put into effect his EU law rights. It doesn't mean that one pretends that the UK system was always lawful. And that's important in my submission when you look at the steps that were taken in the procedural context as it stood at the time that the claims were made.
As I say, I think this is a question
yes,
to be
it's
developed.
a very important question for the substantive submissions in the case.
Yep.
And the other point, Your Lordship mentions exceptions to conforming interpretation, whether it's right to
exceptions to the declaratory theory.
I'm so sorry.
We know from EU law that and indeed from domestic law that it is in theory possible for the law to be declared prospectively only.
Right.
But I'm not aware that there's been any such decision that's relevant in this case.
And that's right in terms of the declaratory theory. The point I would make about that is that the application of the conforming interpretation needs to be sensitive to the general principles of law, of union law in particular effective legal protection and legal certainty. And that is a matter of considerable importance.
I understand that, but as a matter of interpretation of the statute, if it's not prospective only, it follows that it's retrospective.
Well, it depends, or it affects, how that retrospectivity applies to claims that have already been made. as I say, this is jumping well ahead into the substance of the issue.
As I say, I'm just, at the moment, I'm just putting down a marker.
I understand that, and I hope I can reassure you, Lordship, I'm going to deal with exactly that point in both head-on and in some detail. It is an important point in the background, just so we don't lose sight of this, and this is why I asked the court to turn up section 790, that at the time that these taxpayers were asserting their EU law rights, the relevant UK provisions, so in particular 790 sub 4 to 6, they expressly denied the credit for underlying tax in respect of portfolio holdings. Now, that, as we know, has been found to be in breach of EU law. The key substantive EU law issues, they were addressed by the Court of Justice, principally in the context of the FII GLO. There is the reasoned order in the CFC and dividend GLO in 2008. We haven't troubled the court with that because it simply repeats principles in FII CJEU1 and then essentially is overtaken by what's said in FII CJEU2. So that isn't in the bundle, although if the court desperately wants to see it, I'm sure we can provide it. We don't think we'll need to look at that. I'll show the court the key passages of those two judgments in more detail, but for now, can I just give this preview, because the approach developed in important ways. If we start with the ruling on the first reference, so that's FI CJU1, so this is December 2006. The Court of Justice concluded, subject to one point, which was the question that it sent back to the National Court about same tax rates and different levels of taxation, subject to that question, that the credit for overseas underlying tax given to controlled holdings, that was to be seen as equivalent to the domestic exemption. For portfolio dividends, however, the finding was that the UK rules didn't give equivalent treatment because there was no credit for underlying tax. So those rules, the court tells us, were precluded. And as I say, that point, that question that the Court of Justice sent back to the National Court in relation to the controlled holdings, that potentially qualified the court's finding that there was equivalent treatment in the context of the controlled holdings. The way in which the point arose was that the claimants in FII were saying, well, actually, even though there's this credit for tax paid, that doesn't in reality give equivalent treatment. And the reason why that was said to be the case was that under the UK exemption system, the domestic dividends were exempt, even if the company that was paying the dividend had a low or even a zero effective tax rate. So it might have had losses, allowances, any number of different things. And the benefit of that lower effective tax rate for the domestic dividends, that was preserved as a dividend was paid up the corporate chain. In contrast, if we're looking at controlled holdings, foreign dividends, they just got credit for tax actually paid by the foreign company. Just in parentheses, that of course is dealing with controlled holdings. For portfolio holdings, they didn't even get that credit for underlying tax. They just had the withholding tax credit. So for the controlled holdings, the complaint was, if the overseas dividend paying company had that lower effective tax rate, it would lose the benefit of those reliefs and allowances when a dividend was paid out. And that's because the credit was only for tax paid. And that wouldn't have happened if the dividend had been exempt. And so there was fierce argument in FII, both before the High Court and again the Court of Appeal. And of course, there are lots of other questions as well, but fierce argument about what the Court of Justice had actually meant by that question, that it that it's sent back on the first reference, and what ultimately happens is that Mr. Justice Henderson and Lord Justice Etherton interpreted the question in one way, Lady Justice Arden, Lord Justice Stanley Boynton interpreted it in another way. So the claimants, they won on their interpretation, the High Court lost in the Court of Appeal, but the Court of Appeal decides to refer a question back to the Court of Justice for clarification about the nature of the inquiry that the court had asked to be made. And that's one of the things that generates FII CJU2. One of the points that it's important not to lose sight of is that at this stage of the proceedings, this is going all the way back to 2008, 2010, when a number of the claims that we're going to be looking at were actually being made, there was no argument about a conforming interpretation of the UK Schedule D Case 5 provisions. So in FII High Court 1, 2008, and FII Court of Appeal 1, as we'll see, so far as the D5 claims were concerned, the only debate was whether the provisions were lawful or unlawful. Conforming interpretation was raised only in FII Court of Appeal 1, and even then it was raised only in relation to claims concerning advanced corporation tax, which is not anything that we need to concern ourselves with at this hearing, I'm happy to say. It so happens when one looks at this court's judgment in Prudential, the conforming interpretation is actually a matter raised by the court itself rather than the parties' submissions. That's an observation this court makes in 2016. The conforming interpretation, even in FII Court of Appeal 1, is not even discussed by the Court of Appeal in relation to the D5 claims. What happens following FII Court of Appeal 1, of course, is we have the second reference. By the time of that second reference, what had been established was that the claimants in FII had been correct in their assertion that UK dividend-paying companies routinely paid tax at an effective rate that was lower than the UK nominal rate. That was the finding that was made in FII High Court 1. It was a matter really of common sense, one might say, but it was also established by evidence by Mr. Whiting, which was considered by the High Court at that time. Now, that, as we'll see, particularly when one looks at the Advocate General's opinion in FII CJU2, that puts the Court of Justice in perhaps something of a difficult position, because it does rather call into question the court's earlier indication of principle that exemption and credit for tax paid were equivalent. Because if actually systematically UK dividend-paying companies are routinely paying tax at an effective rate lower than the UK nominal rate, it's quite hard to see how in principle the two systems are actually operating in an equivalent way. But of course, on the first reference, the Court of Justice has said, in principle, the two systems are equivalent, subject to this one question that we've referred back. And as we'll see, the court's response to that problem in FII CJU2 was to introduce the concept of credit at the foreign nominal rate. And that foreign nominal rate credit, that was a novel idea. We'll see it originated in submissions made by the European Commission. And what the court held on the second reference in summary was that the UK rules would have been lawful if they'd given credit taking account of the foreign nominal rate. And the reason of principle that underlay that was that credit at the foreign nominal rate would operate like the domestic exemption, in that it would allow the benefit of the lower effective rate of underlying tax to be passed up to UK companies in receipt of dividends. So that's the insight that we get on the second reference. What then had to happen was that UK courts had to work out how to give effect to that case law that the Court of Justice had developed. And that question arose in the context of High Court claims for restitution. And the way, as we'll see, in which the UK courts have given effect to the Court of Justice's rulings is by holding that the UK provisions should be given a conforming construction under which taxpayers in receipt of foreign dividends were entitled to credit at the foreign nominal rate, or FNR, or to credit for actual tax paid if that was higher. An alternative route might have been for the UK courts to have extended exemption for dividend income to the extent that the UK provisions fail to comply with EU law. That, as it happens, was the route that Parliament ultimately adopted when the legislation was amended in 2009, but that wasn't the route that the courts adopted when it came to adjudicating on the restitutionary claims. And in a similar way, a further alternative approach might have been to disapply the charge to the extent that it failed to comply with EU law. But again, in the context of those restitutionary claims, that was not the approach adopted. And I'll show the court some of the reasoning that led to that, particularly in Prudential High Court. So what the UK courts did was they built on the Court of Justice's explanation of what a lawful system would have been required to do. And that is what we'll see in Prudential High Court and following, and also in FII. What that did was it enabled the court to identify the extent of the unlawfulness in the UK system. That's what the conforming interpretation was doing. And in the particular context of the cases that were being decided, what it did was it fixed the appropriate amount of restitution that was due to the claimants in response to their High Court claims, because they had overpaid tax and done so by mistake to the extent that the UK provisions were unlawful. So what's happening under the conforming interpretation effectively is that the claimant's tax liabilities, they're being calculated as they would have been if the UK rules had been formulated and applied consistently with the requirements of EU law. Now, in my submission, the issue that arises in these cases is very different from the issue that is being grappled with in the Prudential test case, the Prudential High Court, Prudential Court of Appeal, Prudential Supreme Court, and also in FII. The issue here is not about ensuring that the right amount of restitution or compensation is awarded, at least not insofar as we're looking at the issues affected by Ground 1. Rather, it's about whether steps that were taken by taxpayers prior to the conforming interpretation being established, do those steps count as valid claims in the first place? Now, the taxpayers sought to assert their rights using the various claims that appeared to be open to them under the rules as they stood. And in my submission, that's particularly true of the paragraph 51 claims, since, as we'll see, the revenue's only position in the FII GLO and its position in its own published guidance was that it was a paragraph 51 claim that was the appropriate remedy. But what the Upper Tribunal has done is to hold that those steps were not effective. The claims that were made prior to the establishment of the conforming interpretation in large measure were invalid. What it did was, first of all, to use hindsight. It said, well, the conforming construction of section 790, that applies retroactively. And what that means is that what was required to be done was you had to make a claim for tax credit, a claim for relief under section 790. And it did that, notwithstanding that, looking at the rules as they stood at the time, that leaving EU law to one side, section 790 told you in terms that for a portfolio holding, the only credit that was available was for withholding tax. So that was step one, had to be a claim for credit. And then step two that the Upper Tribunal took was to say, if you wanted to make a statutory claim, then section 790 was the only statutory route, and none of the steps that had been taken by the taxpayers could be characterised as a section 790 claim. So on the Upper Tribunal's approach, it doesn't matter that taxpayers took steps to assert their EU law rights by reference to the rules as they stood at the time. The Upper Tribunal says, well, too bad. Conforming interpretation is retrospective. You claimed for the wrong thing and therefore you don't get any relief. My submission, just by way of headline, and I'm going to develop this because the detail really does matter in this case, but the headline in my submission is that that analysis that the Upper Tribunal undertook, it confuses two very different situations. The first situation is where a taxpayer doesn't seek to make a claim. That could be for a variety of reasons. Perhaps it's unaware of the breach of EU law, and the taxpayer only becomes aware of the breach of EU law once the applicable national time limit has expired. Now, as we'll see, there's no difficulty with that situation. If a taxpayer doesn't seek to assert his rights in a timely way, then the claim is time barred. And EU law recognises that there has to be finality for the state at some point, and the result of that is that the application of reasonable time limits isn't to be regarded as making the exercise of EU law rights excessively difficult or impossible. So EU law respects the right of the member state to have legal certainty, not to be exposed indefinitely to unforeseen liabilities. And so where a reasonable national time limit, prospectively imposed, is at issue, that right will prevail. That's one situation. The second situation, and it's a very different situation, is the situation we have here in relation to claims that were made before the conforming interpretation was established. Here, we have taxpayer claimants who were very much alive, as we'll see, to the fact that they potentially had rights under EU law. But what they did was use the statutory procedures that, quite reasonably, appeared to be the appropriate procedures for vindicating those rights. The claims that were made, and again we'll see this, they were made in accordance with not just the procedures, but also the time limits which applied to claims of that type. So for example, where the taxpayer made a paragraph 51 claim, it did so in accordance with the paragraph 51 time limit. That's generally the case. There are one or two exceptions which I'll have to deal with, where the step that was taken on the face of it was made not exactly in accordance with the national time limit. So issue 5 is an example of that. There's an amendment to a return that's made actually after the 1 year time limit for amending a return. We've got to look there, well, what do you do with this document that was put in? But generally speaking, what was done in accordance with the applicable procedural rules, including the time limit. As we'll see, the revenue was fully aware of what the taxpayers were doing. The revenue knew that taxpayers were seeking to challenge the validity of the UK dividend tax paying provisions on the basis that they didn't comply with EU law, and looking to claim back the tax that had been unduly levied as a result of that unlawfulness. And there's no objection in procedural terms taken by the revenue to the claims that were being made at the time that they were made. What we'll see, and again, it's put in different ways in the different cases, but what the revenue does is to say, for example, thank you for your paragraph 51 claim, we're going to inquire into it. Or thank you for your amendments, they're going to be held until the conclusion of an inquiry. So there's no point taken as to the procedural validity of the claims at the time when they were made.
So are you running some kind of estoppel?
I'm saying it's not open to the revenue to question the procedural validity of the claims, yes. If your lordship wants to say it's some kind of estoppel, yes, it potentially is.
Okay, that comes as news to me.
Okay. Despite inquiring into
Yes, because the one thing that hasn't been done is there's no attempt to say this is the wrong claim mechanism. The assumption is that this is a correct claim mechanism.
what provision of the tax system? This is a statutory appeal. What provision of the tax system permits that at the estoppel, or is it is it your overarching point that we need to interpret the rules in the way you say we should to comply with the new law?
That's the starting point, is the
Really a
latter point.
conforming. Would it be fair to say that your overarching submission is that we need to do something more to produce a conforming interpretation?
Yes, that's right. That's right. And the conforming interpretation needs to look at the requirement of the procedural rules as well.
Yes, but you've just made a point about estoppel, which to my mind at the moment is entirely distinct. Conforming interpretation is one thing, estoppel is another. Now, which of the issues is your estoppel case?
Well, I'm only saying the word estoppel to the extent that I need a domestic law doctrine. The issue to which it's potentially relevant is issue 2, and I'll explain that when I get there. It's been submitted at all stages before the FTT and the UT that it's not open to the revenue to treat the para 51 claim as anything other than a procedurally valid paragraph 51 claim.
The difficulty we've got, Mr. Brennan, I understand the broad submissions, but the difficulty we have is ultimately we have to look at what the rules say.
Yes.
And apply an interpretation to them, which is why why I asked whether this is really a conforming interpretation.
And that's why I'm focusing on that. I'm not putting front and centre this is a case about estoppel. I'm not saying that.
Sorry, you just told me that you were saying it was an estoppel. So which is it?
No, what I was trying to say in answer to my Lady Justice Falk's question is that my preferred analysis is that the conforming interpretation has to extend also to the procedural rules. That's how I'm putting this.
Yes, I understand that,
also,
but the reason why we got into this question was you made a point that HMRC raised no objection at the time.
Yes.
And that's got nothing to do with the conforming interpretation and everything to do with the potential estoppel, which is why I asked the question.
Yes.
And your first answer was to say, yes, I say it's an estoppel. And now you've just said, no, I'm not saying it's an estoppel, and I'm confused.
Well, I'm sorry, my lord, if I made my submissions in a confusing way. My preferred analysis is the conforming interpretation analysis. It is, however, relevant, and this is whether or not I'm right about conforming interpretation, at what the factual history is. And the factual history includes that no objection was taken at the time. And I can show your lordship how this developed, if that'll help in due course.
Well, we'll get into this in due course, but at the moment I'm struggling to understand what factual history has to do with conforming interpretation. Conforming interpretation is we interpret the legislation consistently with EU law.
Yeah.
Factual history has got nothing to do with that.
That's probably right, my lord. Yes, it's a separate point. It's a separate point.
Well,
It may be
is it
that
relevant to this extent that by taking us through the factual history, including the fact that the true legal position only became apparent some years later, it may be that you point to the factual history as support for the need to apply a conforming interpretation
my lady, that
to grant an effective remedy.
that is fair. Yes. So it comes in at two. It comes in two stages. Because what one has to do when one looks at the conforming interpretation that's required is look in particular at principles of effective judicial protection, principles of legal certainty. And so, yes, the extent to which there is uncertainty about the claim mechanism at the time, that is a relevant factor to how one ought to be interpreting the procedural rules. But perhaps the best thing is, because I will try to unpack these submissions and distinguish them, particularly when I get under issue 2, because there are a number of different routes to the claim being held to be valid, and I hope that'll deal with my Lord Justice Arnold's concern about the interrelationship of the arguments. The point I'm making at the moment is that this is not a case involving some unforeseen liability for the state that is said to arise after some reasonable national time limit has expired. What we're dealing with is a case where, on the basis of the provisions as they were originally enacted, claimants tried to use those provisions, and as we'll see, on a sensible interpretation of what was done, those claims were made within time. Those claims now, on the basis of the Upper Tribunal's analysis, would be undermined because of the retroactive nature of conforming interpretation. Because what the Upper Tribunal essentially says is, because you give Section 790 a conforming interpretation, that is retrospective, therefore you needed to bring a 790 claim. You didn't bring a 790 claim, too bad. And my submission is that that is not a correct analysis. Indeed, it's not a permissible analysis. The reason I say it's not permissible is because EU law and the law of the Court of Human Rights in Strasbourg, from which EU law has taken inspiration on these matters, they're very clear that a claimant cannot be obstructed in making a claim by the retroactive imposition of procedural requirements that did not apply at the time that the original claim was made. And that's why in the skeleton, my submission is that the Upper Tribunal's decision infringes the supervening principles of EU law, and if I can call it ECHR law, it's all, as we'll see, the same, because it's all part of EU law. What those principles require is that the claims that have already been made must be accepted, or they require some opportunity to amend. That hasn't to make the right kind of claims. That hasn't been a focus so far, but that is a potential. That's a potential solution. But as it happens, in this case, we should not actually need to get to those supervening principles, because even if one leaves those supervening principles to one side, my submission is that the steps that were taken by the taxpayers, they were still valid claims. That analysis will require an examination of the requirements of domestic law viewed in the context of the nature and the function of the foreign nominal rate credit that EU law requires.
So this submission is that you get there under domestic law.
Yes.
Without full EU law.
So save by way of context. Yes, because one can't overlook the fact that what these claims are all about is the argument that the domestic rules infringe the requirements of EU law. So EU law is always there in the background.
And just to be clear, your reference to the ECHR,
yes.
Can I understand you rely on that as effectively indicating the EU law approach?
Yes.
You're not making any separate.
No.
You're not placing separate reliance on ECHR.
No, what I'm saying is that the principles recognised by the Court of Human Rights in Strasbourg, they are part of EU law because of the Charter. And I'll show the court that, because of the Charter of Fundamental Rights. So when I show the...
Well, how does that arise, given that the Charter is no longer part of domestic law?
Because we're dealing with matters back in 2009, say, and there's been no argument at any stage, including in this court, that it's not possible to refer to the Charter.
I'm not conscious of there ever being reliance on the Charter and the UT. I may be completely wrong about that. But in any event, if you're going to be relying on the Charter, we're going to have to think about the withdrawal legislation, and we're going to have to think about what the Supreme Court said in the City Flyer case.
Well, At this stage, can I just say it's been common ground throughout that the EU law principles apply with full vigour. That the revenue at no stage, not below, not in this court, has said.
Yes, but I'm taking the point
I understand that, Lord, and
because we cannot act contrary to what Parliament has enacted.
I understand, Lord, and I'll deal with it. Just on the, if I can call it the domestic route, you'll have seen in the skeleton, it's put in a number of different ways. It arises in relation to different issues in slightly different ways, and I'll explain that. Can I just say at this stage, there are three principal routes to recovery. First of all, that a paragraph 51 claim is a permissible route to recovery. Alternatively, that if one needs a claim for tax credits, the steps that were taken, they can and should be construed as a claim for tax credits. What we'll see is that tax credits, they're just a mechanism for calculating the amount of UK tax that is chargeable. And just for your note, that's section 793 sub 1 of ICTA. But if both of those two things are wrong, so if you need a claim for tax credits and a paragraph 51 claim cannot be viewed as such a claim, there is a UK statutory provision, that's section 114 of the Taxes Management Act 1970, which will permit, if there needs to be a correction, that correction to be made so that the claims actually are of the correct nature. Now these matters, they all go to what we call the first key question of principle in paragraph 9 in the skeleton. They're particularly relevant to what the First-tier Tribunal called the category A issues. So that's issues 2, 3, 4 and 5. They're also, as we'll see, highly relevant to issue 9 and issue 10. So that's the sort of headline and overview on what we call the first key question. The second key question, which we note in paragraph 13 of the skeleton, is slightly different in nature. That's concerned with the way that section 790, as conformingly construed, fits together with other relevant UK statutory provisions. And that question is particularly relevant to what the First-tier Tribunal called the category B issues. So those are the issues concerned with the construction of section 806 sub 2 of ICTA. That's issues 6, 7 and 8. And it's also relevant to the issues concerning management expenses. That's category D before the FTT. So that's issues 10, 11, 13, B and E. But what I propose to do, if I may, is to leave that second key question until later in my submissions, actually deal with it as a sort of freestanding topic 2, and then deal with those specific issues. So that's the overview. Please can I deal with the background in a little bit more detail, because that will then allow me to frame my submissions on the grounds of appeal and on the issues in the light of that background. Please may I start just by giving the court a flavour of some of the claims that were actually made. Can I show you two examples? And I'll make my submissions on the analysis of those steps later. What we'll need for this is the supplementary bundle. And I'd like to start, if I may please, with Standard Life. This is the Standard Life European Equity Fund. It's called SLMM in the decisions. One of the difficulties in this litigation is the funds keep changing their names. And in this letter, I think I'm right in saying that at this time it was called the European Equity Manager of Managers Fund. It's Supplementary Bundle tab 3 at page 41. I'm going to try and just call it Standard Life. It's the lead appeal on issue 2, so that's the para 51 issue, and also issue 4, which is the Schedule 1 capital A TMA issue. It may be helpful just to have the first tier's decision available, which is in the core bundle at tab 17. Starting at core page 257. And at paragraph 90, I'm so sorry, it's core page 286. The first tier reproduces with some amendments the agreed statement of facts, and relevant facts relating to Standard Life are in paragraph 90 sub 8 at the top of page 288. So just to be clear, the original way in which this income was dealt with by Standard Life, you can see in FTT 90 sub 9. So the dividend income was returned as taxable with credit for withholding tax only, and tax was paid on that basis. And just for your note, the claim documents, they are actually summarised by the Upper Tribunal in its paragraphs 81 to 82, but I was just going to show you the letter in the original, and that's the letter at page 41 of the supplementary bundle. What you have here, and this is 15th of December 2009, is Standard Life bringing claims expressed to be made under paragraph 51 and seeking repayment of tax excessively paid by mistake. It's the accounting periods, you can see from the subject line, ending March 04, 05 and 06. And it's headed up claim under, this is the last bit of the subject line, claim under para 51, schedule 18, FA 1998 for relief for a mistake in a return. And the commissioners are being asked, if you're going to go to the first paragraph, to treat this as a claim under para 51 for repayment of tax. It said the repayment claim represents excessive tax paid as a result of a mistake in the company tax return for the above period. And then the second paragraph explains why they're going under 51, because the returns have become final by the time the letter was sent. So the 1 year amendment deadline in Schedule 18 was up. That's why paragraph 51 is being used. They don't address this in terms, but at this point in time, the time limit for a paragraph 51 claim, that was 6 years from the end of the relevant accounting period. That's paragraph 55 of Schedule 18 of Finance Act 1998. That's in the authorities, page 169. It reduced to 4 years later.
I know, but the 4 year, the reduction to 4 years isn't relevant for.
Not for this one, because when this claim was put in, it was the 6 year period.
Is it relevant to us at all?
There is one claim, I think, by which time the 4 year period is in place.
I don't think we're told anywhere when that change was made.
I will double check.
2010.
I think it's 2010, and I think it's accounting periods 31 March.
It's all part of the rewrite,
Yeah.
the change in 2010.
I'll double check and
Yeah,
give your
part of the
ladyship
problem we
the
have
date.
is the authorities bundle doesn't always have the correct versions.
Yes. And I'm sorry about that because there's one there's one that I've noticed which I'm sorry about. And
The Upper Tribunal clearly noticed one as well in Schedule 18. If someone could confirm that date of change, that would be helpful.
of course.
It was, yes. Sure.
Paragraph 3 is where Standard Life tells the Revenue what it thinks the mistake is, and perhaps I could just ask the court to read that.
That seems to be asking for a conforming interpretation of section 208.
That's how the claim's been worked out.
Is what you rely on as one of the alternative ways in which the mischief could have been put right, although it wasn't.
That's right. And one of the things I'm going to be developing is how matters would have appeared in 2009 when this claim was being made, and the absence of certainty as to what ultimately turned out to be the correct legal route. Because one
Is the last word in the letter a typo? It says existing legislation. Does he mean
should
litigation?
It should be litigation. I don't recall us ever
But
getting
the reason
into that.
for asking the question is, was a conforming interpretation of section 208 an issue in that existing litigation?
Not at that stage. I'll show you FI High Court 1, my lord.
So what does he mean? If it's not an issue, how would putting this on hold pending the outcome of the existing litigation help?
I'm sorry, my lord. At this point in time, so 2009.
If you're putting on hold
Yes.
pending the outcome of existing litigation presupposes that the existing litigation is capable of resolving the issue. Because if it's not, there's no point in putting it on hold.
Yes, or at least that it will provide insight as to what the answer is. Yes, so either it will resolve or it will help in the resolution of. I see that. That at this point in time, and I'm just trying to remember exactly the chronology, FII High Court 1 had been decided, that was 2008. FII Court of Appeal 1 would have been argued, judgment not yet given. It would have been in debate. It would have been established that the portfolio dividend provisions were precluded. That was the ruling in the first reference in 2006. But there's still argument as to exactly what is going to happen at that point in time. That's probably the most help I can be at that stage. That
I think it's fair to say the analysis had just not got as far as focusing on which UK provisions.
well, no one at this point in time was dealing with the conforming interpretation of the D5 provisions. My friend very fairly accepted below that prior to 2012, conforming interpretation in relation to D5 was just not on the table.
Someone's going to tell me at some stage, well, maybe one of those mysteries of litigation that nobody can explain. But I mean, Mar-leasing wasn't news. Mar-leasing had been decided, what, 89?
So Mar-leasing wasn't news. Vodafone 2 only happens in 2009, I think. There had, of course, been IDT in the Court of Appeal by 2006. But the way in which those cases were being argued, and then this predates my own involvement in these cases by some years, it simply is a matter of fact that when FII High Court 1 was argued out in 2008 and when FI Court of Appeal 1 was argued out in 2010, there was no debate about giving the D5 provisions a conforming interpretation. That just wasn't part of the issues, as we'll see. I should just mention the start of paragraph 4, there's reference to an appendix identifying the dividend receipts and the resulting excessive tax paid. We haven't included the appendix in this court's bundle. The reason it matters is that there was a requirement for the claim to be quantified, but as you'll have seen from the skeleton arguments, there's no requirement that the quantification of the claim as initially made must be accurate. That was the part of the Chancellor's ruling in Class 8 that everyone accepts for the purposes of this litigation. So there's a requirement in paragraph 54 of Schedule 18 that the claim must be quantified, so there must be a number. But it's common ground in this case that the quantification doesn't need to be accurate. We have got copies of the appendix, should the court at some stage need to see it, but we don't think that that's necessary, given that there's no issue about the claim having been quantified. They then deal with Article 56, free movement of capital, and then they explain why they think Article 57, that's the standstill, doesn't apply. And then they also explain why prevailing practice shouldn't be applied to block the para 51 claim, because the court will recall that's a potential defence to the paragraph 51 claims. So their position is you can't refuse the para 51 claim on the basis of prevailing practice, because prevailing practice must be an EU law compliant prevailing practice, essentially. And the revenues reply, that's still in this bundle at tab 4, page 43. And there are various different things going on with different cases, but different accounting periods. The sentence in the first paragraph that's relevant to us is the second sentence, that's acknowledging receipt of the mistake relief claims, that's line 4. And an inquiry is opened into those claims. And then in paragraph 2, the revenue explains what the compliance check is. And they're mentioning Article 43, which is established, but it just reflects that there is still this ongoing litigation concerning the compatibility of the dividend tax provisions with EU law. So those two letters, they're the documents that are principally relevant to issue 2 and issue 4, and I'll deal in detail with what we say as the right analysis and why at that point in time paragraph 51 appeared to be the right route. I just note a couple of things at this stage. First of all, it is clear that Standard Life was relying on its EU law rights and seeking repayment of tax which had been levied in breach of EU law. And the revenue was fully aware that that is what Standard Life was doing. And indeed, at this point in time, December 09, January 2010, the revenue's own case before the High Court and the Court of Appeal, and this remained its case before the Supreme Court in FII, that was that a paragraph 51 claim was the required remedy. There's also, just to complete the picture for Standard Life.
Again, what's the relevance of that? I mean, I understand the jury point that HMRC have changed their tune. I get that. But what's the legal relevance of it in circumstances where we are concerned with issues of statutory interpretation? And it's open to a party to say, I'm sorry, I got the interpretation of the statute wrong. I now say it means something different.
It's more than...
And just to finish the question, If, of course, there's an estoppel claim in private law or a judicial review claim in public law, then different considerations apply. But currently, my understanding is plainly, we're not concerned with public law here. And there doesn't seem to me at the moment to be any private law estoppel. It's purely statutory interpretation.
We are focused on statutory interpretation.
So what's the relevance of the jury point?
My lord, it's more than a jury point, because when we look at the European, two things. When we look at the European principles, they will be infringed where the domestic procedural rules do not provide clarity as to the remedy. Where there is a situation of uncertainty as to what the remedy is, that will be an infringement of the supervening EU law principles, which I'll show you, Lordship, and I'll also pick up your Lordship's question about applicability of those principles. That's point one. And point two is, in my submission, it is also relevant to the construction of the documents that were actually submitted, because it is relevant to know when one is asking what is it that this document actually achieves. It is relevant to know that there is uncertainty as to what the remedial route is. And indeed, that looking at the development of the litigation, that the remedial route that has ultimately been endorsed was not one that reasonably could have been predicted. And that will have an impact in my submission when one looks at this through the prism of domestic law against the background of a system that breaches EU law, in asking, well, does this document actually achieve anything? And if it achieves anything, what does it achieve? So I do say, my lord, it's a lot more than just a jury point. Standard Life did also, as it happens, amend its claims for double taxation relief. That's the letter at tab 6. I don't think I should need the detail of that for my submissions on issues 2 or issue 4. That was done in 2020. It's electronic page 53. So that's what was actually done in Standard Life, and I'll come back to this under issue 2 if I may. And then just to give a second example of these types of claim made before the establishment of the conforming interpretation, this is fidelity, which is relevant to a number of the issues, but principally here issue 5. Fidelity also comes in when it comes to issue 10 and 11, but those issues raise rather different considerations to the ones that I'm interested in under ground 1. And the facts in fidelity, they are summarised by the Upper Tribunal in paragraphs 168 to 170, which is core page 179. But the document I need is actually set out more completely by the First-tier Tribunal, and the Upper Tribunal is summarising in those paragraphs what the First-tier Tribunal had recorded, in particular in its paragraph 146. And that's at core page 313. And can I just make an apology in relation to the bundles, because in the core bundle, the letter that I'm going to ask the court to look at, it's set out in full by the first tier in paragraph 146. In the core bundle, so in the supplementary bundle, that letter has been the appendices to the letter have been included, but not the letter itself. So in tab 20, you'll find at page 104 to 106 the appendices, but not the letter which the FTT has set out. If the court would like it, we've got copies and we can provide those, perhaps at the short adjournment, if you want to see it in the original. But for my purposes, the quotation that the FTT sets out in 146 is sufficient, and perhaps I could just ask the court to read that on page 313 to the top of page 314, second paragraph.
This first paragraph 31, is that the amendment to return?
Yes. So what they were trying to do was amend the tax return, and the reason that we have issue 5 is because they've done that actually after the 1 year time limit.
That appears not to refer to the fact that they're out of time.
No. That's right. But what they do want to do is they want to amend the tax filing positions. Now that can't take effect as an amendment of the return because it's made too late. But what we'll need to look at under issue 5 is, well, what can it do? Because you can see that what they are.
You say they're not trying to amend the return, but they're referring to paragraph 31.
Yes, they do.
So I'm not quite sure I understand any distinction.
No, but you can see if one is simply looking at an amendment to a return, that amendment is made too late, but one has to look at what, if anything, does this document actually achieve? Is it just an air shot, or can it be construed as doing something that does have legal validity? The most obvious thing under issue 5 is as a paragraph 51 claim. And what the first tier explained, having quoted from the letter, is they describe what the computations do.
So just so as to foreshadow what you're going to say on that,
Yep.
as I understand it, you say when we read paragraph 31, as a matter of interpretation of the letter, we can read that as meaning 51.
Yes, that's going to be one of the points I'll make.
Okay, interesting.
Yeah. So the first tier at the end of paragraph.
And just to foreshadow it, that's because it's an obvious error, or
Yes.
obvious error. Okay.
You can't, with respect, Mr. Bremner, amend tax filing means amend the return. It can't mean anything else. It doesn't say we'd like to amend the amount of tax we pay.
No, it talks about the tax filing. That's right.
So it says nothing about tax payments in this.
I accept.
Well, it does. To be fair, though, further down it does say something about additional amounts repayable.
And it talks in the penultimate paragraph about amounts repayable. And so that's one of the matters I was going to refer to.
It seems to me you have to rely on that rather than any reference to tax filing.
The second paragraph says the amendment is to exempt third country dividends. So again, it looks like another attempt to effectively
that's
read down or lease section 208, isn't it?
That no doubt is what they had in mind. If one's asking about the legal, the legal background to what it is that's having an impact on the computation. What they're asking for though is for their money back. And I accept, and we'll look at this under paragraph 15 and paragraph 31 of Schedule 18, under the domestic provisions, they can't get there through amending the return because you get a year to amend your return, and that's too late. But you've got to look as a matter of substance. What is it they're trying to do
Yeah.
here?
Issue 5 really goes with issue 2.
Yes, it does.
aspects of issue 2, doesn't it?
That's exactly right. And I'm going to
raises very similar, some very similar issues.
It does, with the added point that the starting point, as your ladyship is rightly probing with me, is that what was asked for is something that on the face of it was not applicable under the domestic statutory regime. So I have to deal with that as well. But I'll explain. My position very much is if I'm right on issue 2, I get home on issue 5 as well. If I'm wrong about issue 2, it's unlikely that I'll get home separately on issue 5. I quite see that. So the point, and again, the first tier records this is relevant to the various different procedural routes available. As the first tier records in paragraph 146, true it is the amendment was made beyond the time limit for amending the return, but it was made within the period to claim DTR under section 806 or to make a paragraph 51 claim. That's their final sentence in paragraph 146. Of what happened in relation to issue 5, and I'll come back to this in the substance. The first tier says you can characterise this letter as a claim for additional DTR under section 806. That's what they say in paragraphs 149 to 150. And failing which, they say, this is paragraph 151, the letter could operate as a claim under paragraph 51. The Upper Tribunal overturned both of those conclusions. That was 176 to 177 in the Upper Tribunal. On the Upper Tribunal's analysis, the letter didn't do anything. And I'll deal under issue 5 with what we say is the correct characterisation of the letter and also the applicability of the EU law principles. But I hope looking at those two instances in a sort of proportionate way without digging out all of the claim documents for everyone, that gives the court a sense of the time at which steps were being taken and also the nature of the sorts of steps that were being taken. It is, of course, right that different claims are being formulated in different ways and at slightly different times. So those are the claims. Please can I deal now with the breach of EU law and expand on what I've already touched on about the development of the understanding of that breach in the course of the litigation. The development of the cases, it is set out in some detail by both tribunals below. In the Upper Tribunal, it's paragraph 7 to 52. But it is important in my submission to keep well in mind the chronology and what the law was established to be at different points in time. I'm sure the court has well in mind the problem that I identified right up front, that for portfolio holdings it was credit for withholding tax only, express exclusion of credit for foreign tax paid, and no mention of foreign nominal rate credit. And this is all being looked at by reference to the comparison with the exemption system for domestic income. So please may I show the court first where we got to in FII CJU1. So that's the ruling on the first reference. I shouldn't need the supplementary bundle for a while. I need Authorities Volume 6, tab 62. Starting at page 1788. and we, in a sense, we always keep coming back to FICJU1. This is the case that makes very clear the obligation is to accord equivalent treatment as between foreign dividends on the one hand and domestic dividends on the other.
Just before we get into the detail,
Yes.
Can I just ask this question? The last section of this judgment is application for limitation on the temporal effects of the judgment.
Yes.
And one sees the United Kingdom asked for the court to limit the temporal effects of the judgment, and the court said no.
Yes.
So, as a matter of EU law, therefore, the judgment is retrospective, not confined to prospectively, and expressly so,
Yes.
because they were faced with a request to disapply retrospectivity.
Yeah. Yes, and what that means, of course, is that the principles that the UK system has to respect, they apply to prior periods as well. That's right. What we're dealing with, though, in this case, Lord, is the different question of when it comes to the conforming interpretation. How does that interpretation get applied with, if I may call it, sensitivity to procedural steps that have already been taken? And that and the burden of my submission is that that question isn't answered simply by saying that the ruling of the Court of Justice is retrospective and a conforming interpretation is retrospective. That's not a sufficient answer to these claims in my submission. I will develop this.
Okay.
But I fully accept. Temporal limitation was on the table in ECJ1. The UK asked for it, and the Court of Justice said no. That's absolutely right.
Yeah. Okay.
And-
so, where did you want to go to?
And had, just in parenthesis, my lord, had the temporal limitation request succeeded, my clients wouldn't be able to claim for an accounting period that's before the date of the judgment, of course. So that would have headed off the claim in the first place. I was going to pick up question 1 in the judgment. So the judgment starts at 1896. And then the I'm so sorry. I'm looking. I'm asking you to go to the wrong. I'm asking, I think, to go to the wrong ECJ judgment. At least I've opened the wrong. I'm terribly sorry. I think I've given you the wrong page number. I think I've gone to the judgment in ECJ2. The judgment in ECJ1 starts at 1832. Because I fear I directed you to 1896, which is wrong. I'm sorry about that.
That's right. I got it as 1788.
And then
The numbers changed.
I think I just pressed the wrong. Question 1 is what we're dealing with, which is in paragraph 33 of the judgment, page 1838. And it's quite involved, but it boils down to this. What was it compatible with EU law for the UK to have an exemption system for domestic dividends and a credit system for overseas dividends? And then in 35, top of 1839, that's the general principle that while competence in relation to direct tax lies with the member states must exercise that competence in accordance with EU law. 36 notes that either free movement of capital or free movement of establishment could be engaged. And 37 to 38, it's not apparent to the court exactly what the facts are. So as we'll see, they go and deal with both, because it wasn't clear to the court whether it was only being asked to deal with controlled holdings. And of course, for those controlled holdings and establishment, we need the second reference in order to get to the bottom of the unlawfulness. But the way in which this comes about, and I'll take this as short as I can because, of course, the understanding is now more developed, is that paragraph 48, the ECJ, so a third of the way down 1841, the ECJ is telling us that in principle a member state isn't prohibited from using an exemption system for domestic dividends and an imputation system for overseas dividends, but, and this is paragraph 49, and 50, the first condition in paragraph 49 is that foreign source dividends, they can't be subject to a higher rate of tax than the rate which applied to nationally sourced dividends. And we'll see that coming back and resurfacing in a more sophisticated way in the second reference. And then paragraph 50, the second condition is that the member state had to give credit for the tax paid. And
Up to the limit of the
yes.
UK.
Yes. And all of this, just in parentheses, is in the context where the member state has chosen to have a system to deal with double taxation, because the member state could have had a classical system where it doesn't give relief for the underlying tax, and then different considerations would apply. So this is all driven by the starting point of what system has the particular member state chosen to adopt. Now, so far as that paragraph 50 condition is concerned for controlled holdings, we saw the UK did give credit for tax paid, that was 790 sub 4. And so the debate, which the taxpayers eventually won, was whether a higher rate of tax was being applied. And initially, this was the question that was sent back to the National Court. So having said in 53, that's saying that the administrative burdens, they don't make the system non-equivalent. Then there's the claimant's submission, which ultimately is the one they make good, about lower levels of tax lower down. And then 55 was the UK's pass to say, well, that was only highly exceptional. And that's what prompts the Court of Justice to send the question in paragraph 56 back to the National Court. And you can see in paragraph 57, subject to the outcome of that question, the UK think is going to be okay. And that's reflected in the dispositif, that's for the controlled holdings. But for portfolio dividends, there was an infringement of EU law established. This is the discussion on the free movement of capital, which starts at paragraph 58. '58 and 59 are dealing with holdings of 10% or more, so I'll skip over those and what's said in 60, because they say, well, you've got credit for tax paid. It's the same conclusion as in paragraph 57. But then 61, we get to what we're interested in, which is the portfolio holdings, so fewer than 10% of the voting rights, and 61 under the letter G. And the court starts by noting the point I made up front, that the domestic dividends are exempt. And the overseas dividends, it's credit for withholding tax only. Paragraph 62, comparability is established between the situations of the shareholder receiving foreign dividends and the shareholder receiving domestic dividends. And then paragraph 63, this explains the difference in treatment. And if one reads through it, one sees that the UK exemption system, that eliminated the risk of there being a series of charges to tax. That's for the domestic dividends. Credit system doesn't do that, precisely because on its face, the UK legislation doesn't give credit for tax paid. And then 64 having identified that difference in treatment, the finding is that discourages investing capital in companies established in another member state. It also has a restrictive effect when it comes to raising capital in 64. And so that's what leads to the conclusion in paragraph 65 that there is a restriction. 66 and following record various arguments that the UK ran on justification and proportionality, and just cutting to the chase. I wasn't going to deal with the detail of those, or just to summarise them. 66 is the difficulty for the portfolio investor to get the information on tax actually paid. 69 essentially saying, well, what you're actually telling us is we can't have two different systems. And 70 difficulties in identifying the tax paid, but all of those justifications are rejected. And so the conclusion is that the tax legislation is contrary, this is 71, contrary to the principle of the free movement of capital. And then the answer recorded in 72, you got to treat the resident dividend payers and the non-residents in the same way. 73 deals with the findings on controlled holdings. And then 74 is the conclusion in relation to portfolio holdings, and the conclusion is that the legislation is precluded. Is not separately dealt with in the dispositif as it happens, but you can see the answer clearly given in 74, the dispositifs in paragraph 112. We don't get anything extra out of that. So there's no mention in the Court of Justice's analysis of the foreign nominal rate credit, and the reason for that is that at this stage the lack of credit for tax paid, that's enough to ground the Court of Justice's conclusion on portfolio dividends. There's no question of proportionality. The justifications that the UK advanced, they were just rejected. And I mentioned earlier the reasoned order, that was the reasoned order for the CFC and dividend group litigation. Those rulings were simply applied by the court in that reasoned order. That was the 23rd of April 2008. It's paragraphs 40 to 43 if we ever want to look at them, but I don't think we do need to look at them. It just restates what had already been said in the passages I've just shown you. So this is 12th of December 2006. ECJ1, that's establishing that the UK legislation for portfolio dividends breached EU law, and the conclusion is that the legislation is precluded by EU law. And that's why at this stage, and as I understand this was common ground below, exemption or disapplication, that was thought to be the relevant consequence. And that makes sense because we're being told that the UK statutory provisions there precluded. So the UK is not allowed to apply this tax charge precisely because its system was non-compliant.
I think we follow, given that as you said, the Court of Justice appeared to be giving a partial tick to the system in relation to controlled holdings. Why was it assumed that exemption is the right one?
Well, no, what they said was that for exemption or disapplication, which comes to of the charge, which comes to the same thing, because they've told the Court of Justice has told us that these provisions they are precluded. They can't be applied.
In relation to portfolio,
Yes,
you only need to read the same judgment to know that they've given a partial tick to the system in relation to controlled holdings.
Okay.
So why does it follow that the right answer must be a complete disapplication of dividend taxation of portfolio?
Well, I'm not saying it must be. What I'm saying is if all you have is that judgment, you are being told by the Court of Justice that the legislation is precluded, the obvious place to look for a remedy is on the basis that the UK is not entitled to apply those provisions. And as to there being a partial tick, you're looking at a domestic provision which expressly refuses you credit for anything other than withholding tax. It would have been thought to be very difficult indeed to interpret in something that would comply with EU law in the face of that explicit refusal.
Despite Marley's.
Yeah, well, I'll come on and I'll show you. I want to show you metal Gesellschaft in particular, and whether it's permissible for the state to say you should have claimed the very thing that we denied you, and relied on your on your EU law right. I'm simply saying at the moment, in the light of where these rulings have got to, and this is consistent with how FI High Court 1 and FI Court of Appeal were argued, it is not surprising that the basis upon which the claims are being made is on the basis that the either exemption needs to be applied, or, which comes to the same thing, that the charging provisions are not lawful. Now, I said earlier, when FI comes back to the National Court, one of the tasks is to answer that question that was posed in paragraph 56. Mr. Justice Henderson, as was, answered that question in one way. The majority in the Court of Appeal answered it the other way. But decided to make the second reference for clarification. And the point I make about FI High Court 1 and FI Court of Appeal 1, and it is in the nature of a negative point, I can't really show you a paragraph in the judgment, certainly not very easily, is that in those cases, when it came to the Case 5 charge, there was no argument about conforming interpretation. It was simply an argument about unlawfulness, and the working assumption appears to have been that to the extent the charge was unlawful, the restitution claims, which is what's being adjudicated upon in FI High Court 1, would succeed. So I'm relying, I suppose, on the absence of material in the judgments. Just for your note, FI High Court 1, it starts at Authorities, Volume 2, Tab 26, page 335, and the discussion of the Case 5 charge is at paragraph 39 and following, starting at 368. And you won't find any discussion of conforming interpretation. It might just be worth looking at what was being said about ACT, because the parties were clearly aware of the possibility of conforming interpretation. So if we turn up FI High Court 1 in Authorities Volume 2, it's page 404 that I need. This case isn't about ACT. I'm simply making, I suppose, a forensic point. One of the points that was dealt with in FI High Court 1 was the effect of the incompatibility of the ACT provisions with EU law. And paragraph 142, page 404, notes one of the issues is how is that incompatibility to be remedied? And paragraph 144, even for the ACT provisions, in FI High Court 1, there's no argument that the ACT provisions could be construed in a way which achieved conformity with Article 43 EC. So what was actually argued out was essentially competing disapplications, which are then discussed up to 153. The only point I'm making is we don't even get into that level of analysis when it comes to the Case 5 charge. There's just no analysis of those sorts of matters at all. In the Court of Appeal, which is in the next tab, So starting at 486. The Court of Appeal dealt with this as issue 6 on page 529. This court in 2010 thought, in relation, this again is in relation to ACT, that what had been being put forward were alternative conforming interpretations. That's paragraph 100. As it happens, this court in Prudential in 2016 makes the observation that that characterization of the submissions wasn't right. And just for your note, that's Prudential Court of Appeal, paragraph 103. It's page 885 in the authorities. So this court records in 2010, both sides below put forward alternative conforming interpretations. When you read High Court 1, that isn't right. And this court tells us that that isn't right in 103. That's a very long, that's a long-winded way of saying conforming interpretation was on the table so far as this court was concerned in 2010, but only for the ACT provisions. There's no debate about conforming interpretation when it comes to the D5 provisions, even before this court in 2010.
The principles of conforming interpretation, which is summarised there, are of course unchanged.
That's right.
Established by that point.
Yes. All I'm saying is that on the basis of the law as it had developed at that stage, it was not thought that conforming interpretation was an available response to the D5 charge, or at least in the context of those restitution claims, it was thought that the claimants would get home simply on the basis of a finding that the UK system breached EU law. There wouldn't be scope for conforming interpretation, because if the D5 charge is unlawful, then simply it would fall. There was nothing in terms of restriction that would have been justified or proportionate that could have been read into it. So it's ECJ2 that tells us actually about a further respect in which the UK provisions fail to comply with EU law. And ECJ2, FI ECJ2, is back in volume 6 of the authorities. I can put volume 2 away. And that starts at tab 63, page 1866. The court's judgment begins at 1896. And the question that I'm interested in is the question set out in paragraph 35, question 1, at the bottom of page 1900. I just put short that this is the National Court. And I think actually the reference was made, I think, by Sir Launcelot Henderson after the case had been decided in the Court of Appeal. But the reference asks, really, please tell us what was meant by the reference to tax rates and different levels of taxation in the judgment on the first reference. I hope you'll forgive me if I don't take up time with the analysis of that in High Court 1 and the Court of Appeal, because the answer that's given really does move the debate on beyond those matters. So 36, as it so often does, 2/3 of the way down 1901, that question gets reformulated by the court. Paragraph 37 reiterates the court's earlier finding on the first reference on comparability. 38 reiterates the need for equivalent treatment. 39, this is also repeating findings on the first reference. That's the two conditions that are needed in order for the exemption system and the credit system, in fact, to be regarded as equivalent. So again, it's tax rate, letter A at the top of bundle page 1902. Tax rate not higher. And then between A and B, tax credit at least equal to the amount paid up to the limit of the tax charged. And then the court tells us if those matters are satisfied, then the two methods, they are in fact equivalent. That's the start of sentence 2, just over the page break, between 1901 and 1902. And the context and the focus on the second reference is on the controlled holdings, because the credit for tax paid is given for controlled holdings. But paragraph 43, the Court of Justice starts to introduce by the letter H the circumstances in which the rate will be held to be higher. And it gives two examples. The first is in paragraph 44, and that's a difference in nominal rates. That, of course, wasn't the position in the UK. 46 is where the vice comes in, 1903. Profits of the resident dividend-paying company, they're subject to an effective level of taxation lower than the nominal rate. That's the situation they've got in mind as giving rise to a problem. And then in 47, they explain the rationale. And then they do the comparison between exemption and the credit method in 48. And perhaps I can just ask you to read those two paragraphs. And that's the rationale for the finding at 49, which is, if you like, the direct answer to the question. They say the question we were asking in paragraph 56, it relates both to the applicable nominal rates of tax and to the effective levels of taxation. And one might debate textually or linguistically how easy that is to make work, but that's what the court is telling us that they had in mind. So I wasn't going to take up time raking over that ground. So it's both. And then they reiterate the question that they'd asked in paragraph 50. Then 51 refers to the finding that had been made in FI High Court 1. It's the same nominal rate, sentence 2, but then the circumstance referred to in paragraph 46, they say that's present not by way of exception. It's actually in the majority of cases that the effective level of taxation is lower than the nominal rate of tax. And that's why they say at paragraph 52 that the UK imputation method, that's failing to provide equivalent treatment. 53 reiterates the finding of comparability, and then 54, in the light of those two findings, so no equivalent treatment and comparability, 54, you get a restriction. And the result of that, and you can see the court introducing this at 55, is they need to go on to consider justification and proportionality. I wasn't going to take up time with the detail of 55 to 59. Dealing with direct link. 60 is where they start dealing with proportionality. And they say it wasn't necessary to maintain cohesion of the tax system. And then 61 is important. The tax exemption, this is the first sentence, that's granted irrespective of the effective level of taxation to which the profits out of which the dividends have been paid were subject. And then there's a finding about what is the function of the exemptions. That's the second sentence. So insofar as it's intended to avoid economic double taxation, it's based on the assumption that those profits were taxed at the nominal rate of tax in the hands of the company paying dividends. That's the exemption, thus resembles grant of a tax credit calculated by reference to that nominal rate of tax. So that's the understanding of what's going on and the purpose of the exemption system. And then 62 is really the finding that then will ultimately ground the conforming interpretation. That's where the concept of the nominal rate of tax comes in. So looking at that purpose of ensuring cohesion of the tax system, national rules which took account, in particular also under the imputation method, of the nominal rate of tax, Red Short would be appropriate for preventing economic double taxation while being less prejudicial. And then they refer in paragraph 63 to Haribo. They acknowledge that this isn't going to be perfect. That's paragraph 64. There may still be less favourable tax treatment of foreign source dividends. That's if there are different rules in different member states for the determination of the basis of assessment. So they're saying we can't fix that. This isn't going to give perfect equality. But fundamentally what's going on here is a restoration of the required equivalent treatment, or they're telling us what would be required in order to assure a treatment that is sufficiently equivalent as between domestic dividends and overseas dividends. And taking into account of the nominal rate of tax, that is a more proportionate solution. That notion of credit at the foreign nominal rate, it's a new type of credit. There's no dispute that it was recognised for the first time in November 2012 in FICJU 2. The genesis of it is only really discussed by the Advocate General. And this is in the same tab. His opinion starts at 1872, but it's paragraph 38 and following, page 1879. And he's simply recording here 38, through to 45. I'll take this short. The main debate had been claimants saying it's the effective rates of tax, revenue saying no, it's statutory rates, and then he's saying could it be something else? And paragraph 39 says, well, it's only the Commission who've adopted some other solution. And he summarises what the Commission said in paragraph 39, and that was of calculating a credit on the basis of the nominal rate of tax applicable in the state from which the dividends originate. And then he records what the Commission said about that. He rejects the Commission's solution. That, of course, isn't the route that the court went. The court endorses it, but the Advocate General doesn't like the Commission's solution. He says at 42, well, it's not connected to the first FII judgment. And then
Given the court didn't follow the Advocate General's opinion in this respect, how does it assist us?
All I'm saying is this shows the FNR credit emerges for the first time in the submissions of the Commission in 2012, and the only other way in which it assists is he gives a little bit more colour to the nature of the nominal rate credit, which is in the final sentence of paragraph 44, that economically it comes close to a tax-sparing credit. That's the only additional insight into what is going on that you get from the Advocate General.
Yeah, I mean, he accurately is accurate there insofar as he's not saying it's an exemption.
Yes,
Because
indeed.
of course, if the rate is low in the foreign territory, it really isn't an exemption. You have to pay more tax.
Yes, that would be right. Yes, if your ladyship has in mind, if the foreign nominal rate is lower than the UK rate, yes, you would have to pay more then. That's right. So what the foreign nominal rate credit is doing, this is part of alleviating economic double taxation. It's doing that by providing equivalence with the exemption that was applied to the domestic source dividends. None of this is present on the face of the UK legislation construed without reference to EU law. So there is no such credit in the UK provisions. There's no machinery under the provisions as originally enacted through which to claim that credit. Indeed, the UK provisions expressly deny credit for portfolio dividends for anything other than the withholding tax. So what one needs to do is to identify, okay, how is one going to give effect to this ruling? And then what we're particularly concerned with in this appeal is how does one deal with what is the right machinery in order to make claims to give effect to EU law rights? And that's why I'm saying that when one's looking at the conforming construction also has to be sensitive to those remedial and procedural aspects. What I was going to do next was deal with what the conforming interpretation actually is and show you my Lord Launcelot Henderson's ruling in Prudential High Court, which essentially is upheld in the Court of Appeal and then in the Supreme Court. And I want to make a couple of submissions about the context in particular in which that conforming interpretation is settled and identified, and what was at issue and what was not at issue at that point in time. So I think I'm finished with the ECJ for now, in volume 6. Prudential should be in Authorities volume 3, tab 30. Starting at page 712. And the judgment begins at page 720. And this was a resumed trial. The trial had been adjourned for the reference to happen, which produced the reasoned order. And then there was an adjournment again in 2010, which you can see recorded in paragraph 2. And the reasons for that is set out in paragraph 4 on page 721. And the first was that it appeared that all the claims for recovery of overpaid tax were subject to a 6-year limitation period. So these were common law claims in Mistake and in Woolwich. And then secondly, and this is a point I think I'll probably come back to under issue 2, but I'll just note it just now. What had happened as a result of the ruling in FI Court of Appeal 1 is that the Court of Appeal had found in 2010 that surviving claims, so those are common law claims relating to allegedly overpaid corporation tax, they fell within scope of section 33 of the Taxes Management Act or its corporate equivalent, and the corporate equivalent is paragraph 51. And they were capable also in many cases of being raised in open appeals. So the FTT had jurisdiction to deal with those claims, and it would prima facie have been an abusive process to pursue them in the High Court. So that was the position as it was understood when the order was made in 2010. And then, as can be seen in paragraph 8, by 2013, when this case is being argued, those procedural obstacles, page 722, they to a large extent disappeared. And we'd had, in particular, FI Supreme Court 1 decided in May 2012. So what's being dealt with here is the common law claims in Woolwich and in Mistake. We've had ECJ 2. We've had Supreme Court 1. And the main battle line, as we'll see, is the revenue saying the only credit that the claimants are entitled to is the credit for tax paid, because that was established in FI ECJ 1 and in the reasoned order. And the revenue said the additional guidance in FI ECJ 2, that does not apply in relation to portfolio dividends, so the nominal rate credit has no resonance or significance for portfolio dividends. And if that's right, terribly sorry, claimant, you can't prove the actual tax paid, so you lose. And the claimants were saying, no, FI ECJ 2 gives guidance which is more generally applicable. It does apply to portfolio dividends just as much to controlled holdings.
So at this stage, as you earlier said, everyone was assuming exemption or disapplication for no charge. But at least by this stage, HMRC are arguing for credit.
Yes, I'd said prior to 2012, I think is what I said. So by 2013, credit is on the table. And that really, I suppose, is because by then we've had FII CJU2.
Even though that just dealt with dividend control holdings.
Yeah. So people are at least thinking about conforming interpretation now for portfolio holdings. By July 2013, when this case is being argued. And you can see that in paragraph 9 at the top of page 723. This is issue 1. How should the admitted invalidity of the case 5 charge be remedied? Is it conforming interpretation or disapplication? I suppose the other thing that I should say is that Prudential was a life insurance company, and in this judgment there are numerous issues of life insurance taxation have to be addressed. And as I understand it, Prudential was chosen as the test case here because it had more issues than anybody else. So it raises both the general issues and also the life assurance taxation issues. But I'm hoping I don't need to get into the life taxation issues. The judgment sets out paragraph 29 and following a summary of some of the history of the FII litigation. And you can see in paragraph 31 the three important principles established on the first reference, bottom of 728 and top of 729. And then there's quite a lengthy discussion starting at 38 of two judgments of the Court of Justice in Haribo and in Accor, because they were important to the submissions that the revenue was making at this stage. I wasn't going to go into the detail of those two judgments. I was going to pick up a couple of points in relation to what's said about FII ECJ2, which starts at paragraph 65, page 740. And at 75, the observation that a crucial aspect of the Court of Justice's analysis is the principle that an exemption for national dividends is based on the assumption that the profits from which they're paid have been taxed at the full nominal rate of tax in the hands of the paying company. And it's said rightly, well, that may seem highly unrealistic, but this is where the Court of Justice perceived the vice in the UK system. And then 76 seems therefore that the court would in principle accept as compatible a dual system which combined exemption for national dividends with the grant of a tax credit at the foreign nominal rate for foreign dividends. And then that frames the discussion of, in section 6, above paragraph 80, page 746, which is issues concerning the corporation tax charge on portfolio dividends. And again, it's 1 and 2 in the list of issues, conforming construction or should there be disapplication. And then the domestic legislation is discussed, 81. I don't need 82, that's a life tax issue. 83 is the point I made right at the start about the UK provisions. And then the tailpiece is the absence of credit for anything other than withholding tax and the exclusion of the credit for tax paid. And then 84 tells you what the reasoned order did, and that of course is what ECJ1 had also shown. And at the top of bundle page 748, so the basic question, how is a matter of domestic English law, that infringement of EU laws, to be remedied? San Giorgio claims, that was the restitution claim, was a high, there's a San Giorgio claim, no debate about that, and the requirements of the principle of effectiveness. And then 85, perhaps I can just ask the court to read that. That's the two aspects of this exercise, negative and positive. And then 86 is the record of the revenues position, which I summarised earlier, so that the only defect was the failure to give credit for tax paid. That's the first sentence, and then the claimant's submission is, well, no, we now know there's a further defect, and that's the submission that's accepted, that one has to look also at the nominal rates of tax, and that's explained in some more detail in 87, where the claimants make a submission about how you take account of the nominal rate of tax, and you do that by giving credit for the nominal rate of tax in addition to actual underlying tax up to a ceiling of the full amount of the actual charge. And so they can't do any more than extinguish the case 5 charge. And then 88 is the revenues repassed to say, well, that discussion in ECJ2, it's got nothing to do with portfolio dividends. And then there were a couple of substantive submissions made, which are then rejected as to why the discussion of nominal rates can't apply to portfolio dividends. That's the end of 88, and they're set out in 89 and 90, rejected in 91. And then 92, what's happened, you see in the second sentence, that there's a fuller and more nuanced analysis by the court of the problems associated with case 5 charge. And a crucial part of this analysis is the theoretical assumption that the exemption from tax of a dividend is to be regarded as equivalent to the grant of a tax credit at the nominal rate. And the concomitant principle that a state of residence which grants exemption to domestic dividends must at least grant credit for the nominal rate of tax paid in the source state. And then it's the point my Lady Justice Falk was making to me that, of course, you can charge for the difference between nominal rate. And that's applicable, we're told, to portfolio dividends as it is to non-portfolio dividends. And then it's summarised in the last sentence of paragraph 93, so that at letter E, so that's the unlawfulness. Case 5 charge for portfolio dividends, it's invalid for all the reasons that invalidated in relation to non-portfolio dividends, with the aggravating feature, no credits allowed for the actual underlying tax. And then 95 deals with the point on complexity. Is this all too complex? Well, no, the two types of credit are conceptually distinct, says at letter C, and you treat them as alternatives. And then 96 is the finding on what the UK system would have looked like if it had complied with EU law. That's the first sentence. And the dual credit, of course, is a reference back to the point about credit for the higher of the nominal rate and the tax paid up to the limit of the case 5 charge.
Yeah, dual is interpreted as meaning alternative. So it's whichever is the higher.
Whichever is higher, yes.
Yeah.
Yes, that's right. And then there's a point which I'll come back to in the second section of my submissions about the relationship with domestic law, but just pausing on 96. The UK did give credit for withholding tax, and the point in 96 is that's not a requirement of EU law, but it must be granted as a matter of domestic law. That there is then a point that I'll need to address about the order in which the credits arise, and that's relevant to issue 8, but that's something I'll deal with tomorrow. Then there were some additional arguments that the revenue ran which were rejected that I don't need to get into, 97, 98, 99, and then 100 is when we get to the discussion of conforming interpretation. And it's important in this context that at this stage in the analysis that the question is being thought of as being of little, if any, practical significance. That's the second sentence, and that's because a conforming construction which required a dual credit would in practice probably always extinguish the case 5 charge, as would de facto exemption of portfolio dividends if the charge were to be disapplied. But, as it said, the question's conceptually important, so I'll briefly deal with it. And then the principles is set out, and it's Vodafone 2, which you can see in paragraph 101, which is being used as the guide. I wasn't going to go through these principles at this stage. Reference to my leasing in 102. The highly muscular approach that was noted by Lord Sumption in FISC 1, top of bundle page 754. and reference to the declaratory theory in this context at the end of 754. And that
Yes, a later judicial decision to adopt a conforming construction will be deemed to declare the law retrospectively the same way as any other judicial decision.
No, that's right. And I need to show that there's one further observation that Lord Sumption made, having made that observation, which I'll show you, which is that that doesn't mean that there was no unlawful requirement to pay the tax. And that is important. And what is also important is the effect of the conforming interpretation of procedural steps that have already been taken to seek to vindicate EU law rights. But I fully accept that that's what Lord Sumption says. And my position is, and I'm going to explain this and make this good, is that that's not an answer to the points I'm making on this appeal. 103. One sees the conforming interpretation in action. And it's that we're going to read this as providing for the grant of a tax credit for foreign dividends to the extent necessary to secure compliance with EU law. And the point about the grain of the provisions is that it's important in this context that 790 already provides for the grant of tax credits. That, of course, was the credit for withholding tax, both for controlled and portfolio holdings, and for tax paid for controlled. Policy decision is not a problem because we're just securing compliance with ECJ judgments. That's the final sentence. And so 104, that's accepting the proposition that conforming interpretation is possible. It's, of course, a different conforming interpretation to the one for which the revenue was arguing. And then 105 requires the claimant's primary submission, which was disapplication. But then it's noted that Mr. Aronson had been appearing for the case. He displayed little enthusiasm for the argument, recognising that the highly muscular approach was binding. His position had been, well, there's an express prohibition on the grant of the credit in section 790. And then it said, well, that doesn't stop there being a conforming interpretation because there are two answers. Can't be enough to say that the grant of the proposed credit would breach a prohibition in the legislation because the question of conforming interpretation only arises when there is prima facie such a breach. And then secondly, the credit it accords with the general structure and machinery of the section. And then 106.
You've been at points, you've made an overarching point, well, the courts could have chosen to reflect the Court of Justice's jurisprudence in a different way by disapplication. But what's recognised here, including by Mr. Aronson, is that if conforming interpretation is available, you've got to apply it. It's not a matter of choice.
And I'm not saying the court has some sort of free choice. The conforming interpretation, whether that is possible or not, has to be applied by reference to legal principle. So the court is applying legal principle in deciding whether or not the conforming interpretation is possible. What might have been said, for example, is will interpret, I'm sorry, just continuing with that thought, if conforming interpretation is possible and that does the job, there is then no need to disapply in the sense of mould the provision by reading it as without prejudice to EU law rights.
So not just no need, you can't.
Indeed, indeed. So it goes in two stages. There's a slightly different point, which is, well, okay, which provision are you going to give the conforming interpretation to, for example? Because one might say that one can give a conforming interpretation to section 208, but you can see in this case, looking at the factual context of these are High Court restitution claims, we are really interested in looking at to what extent is the tax charge unlawful, because it's essentially accepted that once you...
Hang on, Mr. Bremner, going back to the Court of Justice's decision, it was never equivalent to a full exemption because the credit was only available up to the FNR.
Yes, that's true.
There was always the prospect of top-up tax
Yes.
if the UK tax rate was higher.
Yes, well, and all I'm saying at this stage is that one might have got into a debate about whether that principle could be accommodated in a conforming interpretation of Section 208. I absolutely accept you can't just strike the charge down because the charge or indeed extend exemption generally, because you would only be doing that to the extent that EU law requires it, and that would have been to the extent that the nominal rate needs to be taken into account. None of those matters needed to be looked at in Prudential. You get a sense of why in paragraph 106, when you look at the relationship between disapplication and conforming interpretation. And this actually is picking up, I think, on the point that my Lady Justice Falk has just made to me, that it wouldn't have followed that the case 5 charge had to be disapplied in its entirety. It's only going to be disapplied to the extent it was unlawful. And that, in the circumstance of Prudential, would in practice produce the same result. And that's looking at the matter by reference to Section 2 of the 1972 Act. And the point that's made at the end of paragraph 106 is that whether that obligation is discharged by a process of conforming interpretation of its application, it ought in principle to make no difference. But of course, in this case, we're dealing with a circumstance where actually the precise nature of the conforming interpretation, it has a huge significance for the validity of these claims. And I do say that the domestic mechanism that's ultimately about remedying an unlawfulness or a prima facie unlawfulness in the UK provisions, that should not be having a fundamental effect on whether valid claims have been brought in the first place. One shouldn't be engaged in an exercise of trying to anticipate or guess the precise remedy that a court might ultimately give for the breach of EU law.
Well, maybe, I know we're coming up to the shorter adjournment, you said shouldn't guess the precise remedy. The backdrop to all of this, of course, is that these courts have held that there are domestic remedies in the form of common law claims, restitution claims, mistake-based or verdict-based. They provide a San Giorgio remedy.
Yes.
Those claims are subject to certain time limits. The appellants in this case may or may not have complied with those time limits, which as now are determined to be valid to the extent they still are, as interpreted by domestic courts. Effectively, what you're asking us to do is provide an alternative statutory remedy.
I wouldn't accept that characterisation of it.
But I want you to be
I'm going
aware
to.
of my thought
Of course.
process.
And can I just make, it's only two observations about common law claims. I need to deal with that in more detail, because that's no friend's respondent's notice point, where you could have made a common law claim. That there you are. 2 points at this stage on common law claims, which I'll come back to and develop. The first is that for important parts of the history of this litigation, first of all, the Revenue's own position was that a common law claim was not a permissible route, thing one. Thing two, the Revenue persuaded this court in 2010 that common law claims were ousted by statutory claims, specifically paragraph 51 claims. And so the observation that my lady puts to me actually does rely on hindsight. It's no good if you're looking at whether there's an effective remedy to say, well, we've told you now that you could have made a common law claim. My submission is one has to look at the position as it was when these claims were being made, and what was it a reasonable course of action to make that statutory claim? And is it right that the step that was taken gets undermined by the retroactive nature of the conforming interpretation? That's the point that my submissions are going to invite the court to grapple with. So that's one aspect of this. The other point is that for claims that after 1 April 2010, it is no longer possible to make a High Court claim. And so if you look at the positions...
Well, indeed, and these, that's the changes to para 51.
Yes.
But a separate legal process tells us whether that change was validly made.
No, that's right, my lady. But but what one can't say for claims after 2010, the High Court claim isn't even an option, assuming that the ouster is valid, which at the moment it's been held to be. That, of course, was the burden of the argument in Class 8, which has its own separate appeal, which may eventually find its way to
but my point
this
is
court.
that the common law claims are valid or not valid on their own terms, if you like, depending on whether changes to statute.
Yes, that's right.
Affect
And it is a fact that certainly for a number of these claims, I don't think I can say all of them necessarily, but certainly some of these claimants are the claimants who brought common law claims that were adjudicated on by the Chancellor in Class 8. That's there is an overlap in who the companies are.
Is it an overlap? I thought all these appellants were in Class 8.
I'm not sure if it's absolutely all of them.
Maybe that could be clarified.
It may be that everyone, I think what is right is that everyone who's in Class 8, it may be that everyone who's in Class 8 is in this, but it may not be there, because I don't think there's we'll check and find out. The point I'm making is that yes, it's right that we know now that prior to 1 April 2010, a common law claim was an available route. A litigant at the time did not know that. Standard Life in 2009 could not have known that the right route was a common law claim, not the claim that it made.
I mean, this can just get back to forensic life, can't it? I mean, the law develops and claims have to be made in the light of the law that's understood at a particular
Yes.
time. It may later turn out,
Yes.
very unfortunately for you, I mean, for the university, for the taxpayer, or whoever it is, the claimant, an alternative would actually have been much better.
My lord, that's right. But what I'm going to be engaging with after the short adjournment is in the light of these developments in the law, what does that mean for the steps that were actually taken? Does that mean that they are just of no effect, as the Upper Tribunal's held, or does one either have to interpret these documents so that there is some validity, or is there some supervening principle that gives them effect?
Yeah, all right, we'll pause there. How are you doing time-wise?
I'm doing okay.
Good, we'll resume at 2 o'clock.
Very grateful.
Or advice of April